Babylon, go down dirty Babylon, dirty Babylon, go down dirty Babylon.
There was outcry when Parliament amended the Constitution, which allowed for the retirement age for the holders of the offices of Director of Public Prosecutions (DPP) and Auditor General to increase. In its ruling today, the Supreme Court struck down Section 2.2 of the Constitution amendments, which was passed last year by both houses of Parliament. In bringing the case to the courts, opposition leader Mark Golding had asked the court to rule on the constitutionality of the amendments to Sections 96.1 and 121.1 of the Constitution. The opposition argued that the government hurriedly pushed the bill through Parliament and maintained that it was not consulted on the matter. The amendments facilitated the change in retirement age for the DPP and Auditor General from 60 to 65 years. The bill, which was piloted by Justice Minister Delroy Chuck, was introduced on July 25 last year, then debated and passed in the House of Representatives on the same day. It was approved in the Senate 3 days later. The amendment meant Paula Llewellyn could continue in office for at least another 2 years. It was a second extension for Ms. Llewellyn, who received a 3-year extension in 2020 when she turned 60.
Ready? Good morning again. Before we go into, can you just state your name, title, and your representative, and then you can give us your reaction to this news.
Michael Gilson, counsel for the claimants. When we start our solution to this case, the first thing that we say is that the case is not about the story. It's not about how she did that movie. It's not even really about the extension of the age. The case is about the rule of law, about establishing a principle that the same laws apply to everybody, and that the Constitution needs to be respected. And we think that's what the court is ruling has indicated. So, we are pleased with the ruling, the result of the court effectively saying that the Constitution requires you to say things everybody is saying it and not mix it up.
Does this mean now that the DPP will have to step away from office?
As of today.
As of today. And there's no further challenge that she can make?
Well, I don't know what the government think this is, so you'd have to ask.
Mr. Paul, what's your reaction?
Well, I'll start pretty much the same way. We have always said that this was not about swearing, and it's more to do with our fundamental belief and respect for the Constitution. It is also an important statement on governance. A lot of these things can be avoided, if there is respect for the opposition in power. And this matter could have been dealt with by a conversation with the Prime Minister and the leader of the opposition, and which is what the Constitution requires. And if that were done and respect is given, then we wouldn't have this unfortunate situation now where a public servant is being embarrassed. So I regret that aspect of it for sure. But I believe that the judgment was a good one.
You mentioned that if there was a conversation, there would be no embarrassment. But I'm not sure if this question is for you or for the opposition leader. Would the opposition be minded then to agree on a further extension?
The way a country is run is by people recognizing the role and position of each other, the roles and position. And sometimes these matters are settled by the leaders. In a room, used to be the Bay Royal, confab, and that is how a mature democracy operates. We shouldn't have to be in Parliament one day summer to pass a law without the requisite respect and consultation. And I think this is fundamentally a commentary on life.
Mr. Powell, given this ruling, can we expect to see the opposition challenge, bringing more matters like this in matters where they feel like the government did not, break some protocol or did not consult with them in a way that the Constitution dictates?
We are quite clear. Our role is to protect the integrity, the sovereignty of the Constitution. And anywhere we see violations, we're going to pursue.
Thank you. Good.
Thank you, King's Counsel. We're gathered here today for the delivery of the decision in the matter of Philip Paulwell et al. And the Attorney General of Jamaica. King's Counsel having announced the representation, we will now get into the reasons for our decision. We will commence with the issue which the court had to decide, and that was whether sections 96(1) and 121(1) of the Constitution of Jamaica were validly amended by the Constitution Amendment of Sections 96(1) and 121 Act 2023, which we have referred to in our judgment as the Act. The facts in brief, which we have found, are that in July 2023, the Act was passed after a majority vote in both Houses of Parliament. The Act now contains Section 2(1), which increases the age of retirement of the DPP, and Section 2(2) is a new section, which gives a right to the DPP to elect to remain in office despite the role of the Prime Minister and opposition leader regarding an extension of tenure. This right applies to a DPP who is 60 years of age. The incumbent DPP was born in 1960 and had reached the retirement age of 60 under Section 96(1) of the Constitution. In January 2020, the DPP requested an extension of tenure. The Prime Minister initially proposed a 5-year extension, and the Governor General approved a 3-year extension which expired in September of 2023. In February 2023, the DPP sought another extension which was declined by the Public Service Commission, referred to in our decision as the PSC. That refusal was in May of 2023. The PSC then cited constitutional limitations on the grant of a second extension, as well as the refusal of the Prime Minister to grant the extension. Following the PSC's decision, the Act was passed. In response, the DPP submitted a letter to the PSC electing to continue in office until the age of 65. The PSC approved a 2-year extension from September 21, 2023, and recommended that the Governor General appoint the DPP. His Excellency made the appointment based on the PSC's recommendation. It was argued before us that, by the claimants, that the amendment is unconstitutional and should be struck down on the basis that the current DPP has already received 1 extension in office and should not benefit from the Act which seeks to grant a second extension. The incumbent would benefit from a de facto extension in a manner not contemplated by the Constitution. In addition, the claimants contend that the Act bypassed the legal process for extending the DPP's retirement age, effectively usurping the powers vested in the Governor General and the opposition leader. In support of their position, the claimants exhibited evidence of the debates in Parliament. The defendant argued that the Act was passed in accordance with the manner and form required to amend the Constitution and is therefore valid. The defendant asserted that Parliament holds exclusive jurisdiction over its internal affairs, and the court cannot interfere with its procedure. The defendant submitted that neither of the Houses of Parliament had authorized the claimants to present evidence of parliamentary proceedings in court, and therefore such evidence cannot be considered as provided by Section 11 of the Senate and House of Representatives Powers and Privileges Act. We now move to the decision of the full court. This court has ruled that Section 2(1) of the Act is constitutional. Section 2(1) of the Act has amended the Constitution as regards the retirement age of the Director of Public Prosecutions. A new provision introduced into the Constitution by Section 2 of the Act grants the DPP the option to remain in office after age 60, and this gives the DPP a level of authority not envisaged by the Constitution's framers. Section 2 of the Act is not a valid section and is severed from the Constitution because the process remains unchanged for extending the retirement age. Section 2 is unconstitutional, null, void, and of no legal effect. On a proper interpretation, Section 11 of the Senate and House of Representatives Powers and Privileges Act did not prohibit the claimants from exhibiting the proceedings in Parliament. The reasons for our decision are as follows. The incumbent DPP has already reached the extended retirement age. This means that the application of Section 2 cannot lead to another extension in office by way of an election on the part of the incumbent DPP, as this is unlawful. Section 2(1) of the Act as currently formulated has raised the retirement age without addressing the extension of tenure in office. Consequently, any extension of the DPP's tenure under this section must adhere to the same process outlined in the previous Section 96(1) of the Constitution, which remains unchanged by the Act. The only lawful method to extend the DPP's tenure remains by way of an agreement between the Prime Minister and the opposition leader. Given these considerations, there is no necessity to delve into the application of Section 2(1), nor does it require reading down. Section 2 of the Act is the offending provision, and the Court holds that it is incompatible with the Supremacy Clause. In light of the foregoing reasons, this Court orders as follows. Judgment is entered for the claimants. This Court declares as follows. 1. Section 2(1) of the Act is a valid constitutional amendment. 2. Section 2 of the Act is an invalid constitutional amendment. 3. Section 2 is severed from the Act and is struck down and declared as unconstitutional, null, void, and of no legal effect. The parties may write and file and exchange their submissions within 7 days of the date of the orders made herein. On costs. In addition, the decision on costs will be heard on paper. We'll now hand down the decision, Mr. McCarthy.
Well, it seems that the claimants have prevailed. The court has ruled that the second extension granted to the DPP to stay beyond the age, the first extension, is unconstitutional, null and void, and of no legal effect. This means that the DPP will have to demit office immediately. That is the judgment of the Supreme Court in the matter of Philip Paulwell versus the Attorney General of Jamaica. I did hear her say the decision to be handed down by, are we still hearing from them? Let's listen. That's it. Yes? Yes. So it seems, yes, that the government has lost. The opposition has won, yes, in its claim that the move to grant the DPP a second extension has been declared unconstitutional and of no legal effect. It means that the DPP's time has come to an end in office. She will have to demit office, and we will have to have a new DPP